All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Joe Boatwright, Judge, presiding. All persons having business before the court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal oral arguments this morning, located in Citrus County. Thank you for having us. Before we get started, let me introduce the judges on our panel. I am Judge Boatwright. To my right is Judge Eric Eisnagel, and to my left is Judge John McIver. This morning we also have some school groups here with us, so thank you for being here with us, and we will try to leave some time at the end of the proceedings to allow you to ask some questions. Also, since we do have quite a few people here, if you could please silence your cell phone or any other device you have at this time, that would be greatly appreciated. We do have 2 cases on the docket this morning. Each side will have 20 minutes to argue their case. The appellant is allowed time for a rebuttal argument, and so when you come forward, please let us know how much time you would like for rebuttal. The first case we have on the docket this morning is case number 2022-2725, Bogle versus Williams. And so is the appellant ready?
Yes, Your Honor.
Okay.
Good morning, may it please the court. Kevin Franz on behalf of Sean Bogle as personal representative of the state of Cindy Farrington. Respectfully request to reserve 5 minutes for rebuttal.
Okay.
Farrington was denied a fair trial for a number of reasons, and we request that this court reverse and remand for a new trial. The first issue is race. Williams' race was improperly injected in the trial of this case. It inflamed the passions of the jury. It's highly prejudicial and deprives the defense of a fair trial. This is a run-of-the-mill auto accident case.
When was race brought up during the voir dire?
It was brought up twice. First, it was brought up during voir dire, and then in rebuttal closing argument, which is basically...
Is it not proper to question potential jurors about racial bias?
No. So the United States Supreme Court basically indicates that when race, and this comes from Rosales-Lopez versus U.S., when race is inextricably bound up with the conduct of trial and the substantial likelihood of racial prejudice will affect the jurors in the case.
Did the trial counsel object?
Trial counsel did not object to the voir dire, and we realize that that is not preserved. However, there was the issue during rebuttal closing argument was preserved, and the argument in rebuttal closing directly discussed that race was brought up during voir dire.
Did counsel below ask for a mistrial after the closing argument issue?
Did not issue a mistrial, but there's no requirement to do so because when the judge overrules an objection, it's preserved on appeal. Only if it was sustained would there have been a requirement to move for a mistrial. So in this case, because the trial court judge allowed the discussion on race to continue,
it seems like that's a pretty low bar for inextricably bound up in the case. Questioning during voir dire and then one reference during rebuttal closing argument is inextricably bound up in the case.
Well, no, the only time you're allowed to discuss race is if race is inextricably bound up with the case. For example, if this was a civil rights action or something along those lines, that is when it would be appropriate to discuss race. But this was a run-of-the-mill auto accident case where race was not an issue whatsoever.
Counsel, what's the most inflammatory on this point? What's the most inflammatory statement
So
that was made?
In closing, if I could say just in voir dire, initially it was a question of my client is black, would someone keep a closer eye on somebody because of race? And then the most inflammatory part of closing is that the plaintiff said that the defense is clearly suggesting she didn't really hurt. And I brought up a topic that was very uncomfortable, which was race during our jury selection. And then the counsel continued after he was allowed to continue that you
There was an
believe
objection. There was an objection, right?
Yes, well, in fairness, the judge immediately called the parties up to the bench when this occurred. Because there was obviously something wrong with the counsel said, Your Honor, and they approached the bench. and plaintiff argued why he should continue to talk about race. We said that should not happen, and the judge said, no, you may continue. And then the plaintiff's counsel parlayed race into, you believe the concept of equal justice and justice for all are not just words, they are something worth standing up and fighting for. And essentially what this did was suggest that race plays a part in the defense that Williams, quote, ain't really hurt. Because our defense was, in fact, that she suffered degenerative issues with regard to her back, not severe spinal injury as she claimed. But what they did was they invoked outrage at the defense by questioning Williams' veracity in terms of the severity of the damages that she's claiming simply because of race. That was the tie-in. That's why they said it. That's why they brought it back from the voir dire to the closing argument.
I mean, at most, that was implicit. Right? I mean, there was I didn't see any express statement.
Well, but it's, as Your Honor said, it's implicit. That's what they're saying. They're saying, watch out for her. The defense is saying, well, she ain't really hurt, and what we're concerned with is the court looking, or the defense looking at her and saying she ain't really hurt because she's African American. So not only does it invoke outrage, or implicitly invoke outrage at the defense for suggesting that Williams' veracity should be challenged because of her race, but it also invokes sympathy for the plaintiff because he ties it in with equal justice for all. This is an auto accident case. Again, this is not a civil rights action. He ties it in with, quote, equal justice for all, that it's something that would, of course, include all races, and, quote, something worth fighting for. This is being completely brought out of simple auto accident case to slamming the defense for questioning Williams' veracity.
Counsel, where in the initial brief do you argue that it raises sympathy?
We don't use the word sympathy in the brief. However, we do argue that this inflames the passions of the jury and that race is something so severe that it calls into question the entire judicial system. How do we know that? We know that from the Murphy case. And of course, in Murphy is when there is, this is the Murphy versus robotics, dealing with an unpreserved argument. And it's so incredibly hard to satisfy the four-part test because of the fourth part. And the fourth part says the closing argument has to be the type that, quote, so damages the fairness of a trial that the public's interest in our system of justice requires a new trial. And what is the example that the court gives as something that rises to that unbelievably high threshold? Appeals to racial prejudices, which is why race should not be anywhere near this type of action. And it was it was bookended with this. It was brought out in voir dire, and the very last thing that the jury heard was equal justice for all. The defense is, again, implicitly questioning her veracity based because she is black. This is the perfect example of something that so injected the trial in this case that inflamed the passions of the jury and it deprived the defense of a fair trial. The next argument we have, Your Honors, concerns the collateral source instruction. The collateral source instruction was given.
Counsel, why don't you take up the slides?
Okay.
The expert witness.
Yes, Your Honor.
Car accident, the comparisons between those and then the MRIs.
Yes. So the slides that Dr. Reinhardt wanted to use were 4 substantially similar accidents to the present accident, which would have assisted him in discussing his causation and damages testimony, which of course is the heart of this case. Our major defense was that this was a low-speed, minimal impact case.
Let me just stop you just a minute so I understand. How big was this PowerPoint originally?
It was quite large. I don't know how many slides.
Prior to Dr. Reinhardt testifying that some of these slides were removed, correct?
Not exactly. So these PowerPoint slides were given to plaintiff's counsel 6 to 8 weeks before trial. The night before, this in the middle of trial, the night before.
3 or 4, but okay. My understanding, and looking at the record, and you correct me if I'm wrong, is that it was quite a large PowerPoint, and the two sides got together and some of these slides were actually removed before the judge removed the 3 or 4. Is that
Yes,
correct?
That is correct, Your Honor.
So we're talking 4 for the MRIs and 4 for the traffic accident that the judge excluded.
4 for the traffic accident, I believe 2 for the MRIs.
Okay, and how big was the PowerPoint once you excluded those 3 or 4? I mean, did he still have an extensive PowerPoint?
He did have an extensive PowerPoint, but what was missing from the PowerPoint is what is so critical, and that is the 4 substantially similar accidents. So the law is that accident reconstructionists can bring in comparisons of other accidents if they're substantially similar. What the law in Florida is that you can never get any comparison accidents that are identical. It's basically impossible, and the courts know that. And we cited a couple of cases, Dempsey versus Shell Oil, where it was an abuse of discretion in excluding test results from an experiment regarding automobile headlights, even though the conditions weren't identical. The court said any difference goes to weight, not admissibility. So in this case, we had Dr. Reinhardt, his employer, created ran tests of cars regarding the speed, force, damage measurements.
These were demonstrative aids, correct? You were trying to enter them into evidence, correct?
Correct, Your Honor.
Okay, did he still get to talk about similar traffic accidents, similar MRIs?
He got to speak about them,
I
but
just didn't get to show the pictures.
But yes, but a picture is worth 1,000 words. And in this case, what is so unique about this case is the nature of the vehicles involved. It was an override-underride accident with a much larger vehicle in the back. So usually when you have 2 cars at the same level, bumpers are hitting one another. The level of force will probably be indicative of the damage that we see. But in this case, you had a much higher vehicle in the back where the bumper of the higher vehicle strikes the softer material of the lower vehicle, which is just the trunk. And it makes it appear that it's a much more significant damage, which is what the jury got to see when they got to see the actual photos of the vehicles. But what this demonstrative aid shows is similar delta the impact and the force of these types of vehicles around the same weights, around the same sizes. To put in perspective our position that this was not as significant of an impact as the photos of the impact would lead you to believe. And of course, we're entitled to raise a defense and not just make argument on it. If there are demonstrative aids that will assist the jury in understanding the testimony of an expert witness, that's perfectly allowable. And that's what all the cases that we cite, GMC versus McGee, Dempsey versus Shell Oil, this is a common thing that happens. And this was so damaging to the defense when you look at the cross-examination of Dr. Reinhardt, because he was asked, well, you didn't conduct a reenactment of a collision. How could a delta V of only 2 to 4 miles per hour produce this much damage? You had limited pictures with which to reach your opinions. These are all things that the doctor would have been able to say, well, wait, actually, yes, I've done all of these things. Let me tell you about it. But the plaintiff used this victory of getting it excluded to their advantage.
Once the plaintiff did that, did you attempt to get the slides in again?
No, we did not at that point.
Probably should have, right?
Probably should have, but at that point, there was already a ruling made that was excluded.
Yeah, but then the other side starts capitalizing. It's probably should have asked to put them in after that, right?
Well, the plaintiff said he would move on at that point, but the problem is the PowerPoint presentation, which again, we had been prepared for 6 to 8 weeks, was for him to discuss this on during direct testimony. So you couldn't put that back in the box. We were not able to do, I mean, you can redirect, but we couldn't start the direct over with the presentation that he had prepared. And it shouldn't be lost in this
You
court.
couldn't have used the slides at that point. In rebuttal, you couldn't have used the slides, then why?
We could have used the slides, but it disrupts the flow of.
Well, okay, I'm not sure disrupting the flow is there a case out there saying disrupting the flow is reversible error on appeal?
Well, I wouldn't say that, Your Honor, but I would say that the point of disclosure deadlines is so that the parties are able to present their case without having
Or
to.
has substantial discretion on those kinds of things, right?
The courts do.
Right.
But
So if your side had counsel on your side attempted to then, after cross-examination, capitalize, at least arguably capitalizing on the exclusion, had counsel then said, well, Judge, they've opened the door now, they've made an issue of this, wouldn't your case on appeal be a lot stronger?
It would be stronger, but again, we have to look at the initial ruling. The question is, did the judge abuse his discretion when he ruled initially? This is before any of this happened or opening the door happened. Were these slides admissible? Should these slides, was it an abuse of discretion to preclude the doctor from testifying about these slides in the first place? That's the issue on appeal. Was that an abuse of discretion? What occurred later, Monday morning quarterbacking in hindsight 2020, probably in every trial attorney would have maybe done something different when they had the time to think about it. But that's the problem with this case, is that the plaintiff's counsel had this for 6 to 8 weeks. In the middle of trial, this was essentially trial by ambush. This was a gotcha. The night before Dr. Reinhardt was going to testify about this, the plaintiff said, I just looked at this PowerPoint presentation and I don't think half of this stuff should come in. That is the whole entire point of pretrial orders, so that you have motions to eliminate deadlines or exchanges of exhibits. So you have these things done before trial, because attorneys are allowed to be under the impression that once trial comes, you should be able to present
How would
evidence.
the court write that up in an opinion? We'd say, hey, if somebody brings an objection late at trial that they should have brought weeks before, that is automatically an abuse of discretion.
No.
Trial judges no longer have discretion.
No, I would say that's a secondary issue.
How do you write it then?
Well, the first issue is, under the Dempsey case, it's an abuse of discretion to exclude these demonstrative aids if they are substantially similar. That's what the law is. And if this court finds they were substantially similar, then it was an abuse of discretion. Dicta, I would suggest, would be that also the plaintiff had this for 6 to 8 weeks. This is trial by ambush. The night before this gentleman is going to testify, he's told he can't, part of his testimony is gone. That would not be the holding of the case, but the holding would be that it was an abuse of discretion because accident reconstructionists are allowed to bring in substantially similar accidents, test results that they have done. That's what the law in Florida says, and so Your Honor could simply rely on GMC McGee, Dempsey versus Shell Oil. From this district, Carroll versus State, an experimental demonstration was allowed where conditions are substantially similar to that victim's in the current suit. So that would be, I try my best to answer Your Honor's question in that respect.
I don't want to cut you off, but you are in your rebuttal time.
Your Honor, based on that, I would rest on the additional arguments that we have in our brief and respectfully request that this court reverse and remand for a new trial.
Mr. Lee?
May it please the court. My name is Brian Lee. I am representing Meg Williams, the appellee in this case. All issues in this appeal are subject to the abuse of discretion standard, as this court knows, and we have argued, and we believe that it's shown for the record that none of the arguments that were set forth by the appellant in this appeal warrant a new trial. The trial court did not abuse its discretion in denying Farrington's and now the appellant, Mr. Vogel's, new trial motion on any of the issues that came to trial. We are dealing with, in this case, I'm sorry, Your Honor. Yes.
Abuse of discretion can be departure from the essential requirements of the law, so can you quickly for us distinguish the cases that your opponent is saying control here with the demonstrative aids? If they were substantially similar, did the judge not abuse his discretion?
Sure. As far as the poppy damage and the MRI, so that when we're dealing with issues of demonstrative aids, the trial court has, and the case law says, has broad discretion over that. Because of the fact that these are not even going to the jury, these are just aids that the expert is using, it's why that broader discretion is there. To show an abuse of discretion for a trial judge disallowing demonstrative aids, essentially the appellant has to show that no reasonable judge would have done the same thing. And when we look at what happened in this case, it's important to know what the facts were. There was an extensive PowerPoint by this expert. Prior to even the judge making the determination of which slides were in and which slides were out, the parties had gotten together, I think it was that night, maybe the next morning, and actually took out some of the ones that were that were going to be part of that argument. And so we were talking about just a finite amount of slides. And what we were dealing with were slides that showed other property damage from other crashes, and we were showing two, I think, of other persons' MRIs, not Miss Farrington's. And so we're talking about within property damage estimates of those photographs, and frankly, Your Honor, it shouldn't go past this court that these were property damage crashes that were tests performed by the employer of the expert. And so when we're talking about a discretion that a trial court has, part of this substantially similar also talks about the veracity of these types of tests. When we're talking about a trial court allowing tests that are done by the employer.
Is it veracity going to be the jury question?
It is, Judge. It would be if it's allowed there, and obviously the record doesn't say specifically what the trial court gave some of its reasoning, but when we look at it as a whole, this expert was able to discuss everything he wanted to discuss about other crashes, other types of MRI. This is how this MRI would look. This is Miss Farrington doesn't look like that. And so the only
So why not allow the demonstrative aids in that? You know, if it doesn't matter, right? And obviously relevant, the expert testified to it all. Why not let it in? I mean, what's the basis? I don't understand.
I think there is a line that a trial court has to draw when you are talking about things that are going to go up in front of the jury. And so when we're talking about, and sort of I think the floor that we deal with is it has to be relevant to the case.
Well, it's clearly relevant because the expert testified to all of it. You just said that, right? The expert testified to all of it. So the subject matter is relevant. The question was, should the demonstrative aids have been used?
Right, and I think, and certainly, even if we talk about relevance, is it marginally relevant? Maybe. But then we talk about whether there's another step of that. Does the aid or does that testimony, is it more prejudicial than probative? Showing the jury pictures of what other crashes were, ascribing delta V's, which is what this expert wanted to do, to that particular property damage, there's only one reason you do that. Is to say, well, this delta V in this crash was higher than the one I'm saying for this one, so that person's not injured, Miss Farrington isn't either. Same with the MRI. This MRI shows an acute, by the expert, injury. This MRI by Miss Farrington doesn't. Right. So that means that this person was injured, Miss Farrington wasn't. To use other person's MRIs, different characteristics, different people, different stages of life, to use other property damage from other vehicles, different
How is it relevant to show a picture to say, hey, look, here's the same delta V, right? Calculation for I guess I'm not a scientist, but force, right? I guess something roughly. And here's what it does in a similar situation when the truck is lifted and hits not the bumper of the car, but something above the bumper. Here's what it looks like with the same force, right? Now, certainly you can cross-examine that and tear it apart, or, cross-examining the expert, but why is that not relevant for the jury to look at so that they can compare? Okay, well, was this truck going 30 miles an hour or 3? Why is that not relevant?
Because when you're talking about things, force calculations and delta V calculations, all those engineering type calculations are very specific to a crash. They are specific to what type of vehicle hit and got hit. They're to the person that's in it, to the angle that the hit is happening.
Isn't all that stuff sounds like it's for cross-examination to me. Why not? Why is that not for cross-examination?
Because when you there is a point in a trial court analysis where it is, in the trial court's mind, is not similar to the particular case that they're dealing with, to the crash and to the MRI. If it's not substantially similar to a trial court, the trial court has to bake that, and that's not a line that the District Courts of Appeal or the Supreme Court has said, here's where it is. And if you have all these in Delta V, this is where the line is. It's a very gray line. And the trial court has the ability in those situations to sit where that line is. This trial court below decided, I'm going to let the expert talk about what his methodology was. I'm going to let him talk about how the methodology involved looking at these other things, but I'm not going to allow him to show these things to a jury. Could he have went the other way? Absolutely. And then we'd be in front of you saying, if we were the ones that were the appellants, we'd be saying that he abuses discretion. But in this case, there's nothing that shows that where this trial court drew that line was an abuse of discretion.
The trial court, he wasn't saying that it wasn't relevant. He was doing a balancing test that was overly prejudicial. Am I correct about that?
Correct. He said that it's more prejudicial than probative, which is that second part of the analysis.
Right. So it wasn't that it wasn't relevant. He just determined in his mind whatever relevancy was there was outweighed by the prejudicial effect.
Correct. At the end of the day.
And I guess that's where I'm just lost. Explain to me what the prejudicial effect is. When the expert was allowed to say it all, why can't the expert then show it, right? It's sometimes for a layperson difficult maybe to follow some of this stuff, right? Why, if the expert can say it all, where's the prejudice in saying, here's what I'm talking about?
We don't know particularly because obviously we know there were slides. We don't know what these slides were. We don't know kind of what was on them, how they showed it, things of that sort. So we don't really have a good sense, I believe, of how these were set up. That could mean something to our trial court. But I do think at the end of the day, this is very much akin to photographs that we see. If there's photographs showing a lot of injuries, the trial court makes a decision as to, okay, I'm going to let you do these 4, but I'm not going to let you do 20 of them. The trial court makes those calls with that type of evidence. And this court cannot second guess those calls unless it finds that any judge wouldn't have done the same. And I don't think that that's the case in this case. I think this judge did what he felt was correct, and we believe that he was well within his discretion in doing that.
Let me ask you, the appellant brought up, was race an issue in this trial?
Certainly, Miss Williams was an African-American woman, and so the voir dire question, and I want to juxtapose what the appellant is saying. The appellant is saying in this case that Mr. Mitnick, I guess in his voir dire, as well as his rebuttal, was saying that the appellant was injecting race in the sense that the appellant was saying that because she's African American, that means you shouldn't believe her. That's what they're saying we said. When you look at the record, it is very clear that Mr. Mitnick in voir dire is determining whether the juror or the potential jurors have a preconceived bias about either African Americans in total or African American women. As far as pain complaints,
That's not focused on work, but I wasn't objected to.
Sure.
Let's talk about focusing on the closing argument.
Sure. Yes, and so the closing argument, and again, you have to realize Mr. Mitnick was in the middle of that closing argument when there was a sidebar and the judge allowed to do, and what ultimately came out from Mr. Mitnick is that we asked you those questions in voir dire, and both parties feel confident that none of you said that was going to be a factor in your termination. There was nothing in his comments in rebuttal that says, well, the defense is saying that that she's not telling the truth, or that she's exaggerating symptoms, and we think that might be because they're talking about her race. There's nothing like that.
Well, they were right next to each other, weren't they?
Well,
Could you read it to us?
Sure.
I think they were right next to each other.
Sure, so, let me get that.
Maybe I misremember, but that's how I recall it.
Yeah,
So
so.
there was the one statement and then followed immediately by the reference to race, right?
Right, so he,
So what's a jury to take when?
right, okay, so after, I'm sorry, I'm looking at my brief here. I don't have the comments because he was cut off, but I do have the comment where he, after the sidebar, after the trial court said he would allow Mr. Mitnick to talk about it, Mr. Mitnick said to the jury, I went through that, so we can rest assured this case would be decided on its merits and its merits only. And I thank you for giving us that peace of mind. That's what he said. There was nothing, there was not a hint of saying that.
For the sidebar.
Right, and I don't have that, Your Honor. I put it in my brief. I could look at it to see whether I can find it in the trial transcripts.
I think that was maybe where the part I'm talking about.
Sure.
I'm trying to find it too.
It's 1273, that's what I cited to, Your Honor. But for some reason, my trial transcript is not coming up.
Did they not say, was the, essentially, something like, they say she's not hurt at all, and then the very next sentence going into race?
No, Judge, I believe, actually, I'm sorry, and it might be in the initial brief, as I'm thinking about it. Let me see if I can find it.
One other topic that I covered with you is you can see all that treatment she's had, and you can see the defense is clearly suggesting that she ain't really hurt. And I brought up a topic that was very uncomfortable, which was race, during our jury selection.
Right.
Pretty close.
Yeah, well,
Pretty close.
and again, I think that.
How do we interpret that? How do we not interpret, that's not two different sentences right next to it, that's the same sentence.
Sure, but I think you have to then put it in context of what Mr. Minnick said next, which is that we, and that's what I read to you. I went through that so we can rest assured this case would be decided on its merits and its merits only. And I thank you for giving us that peace of mind. He went on to say, I thank you for being the type of jurors when we went through jury selection, you said clearly that you believe the concept of equal justice and justice for all are not just words. They are something worth standing up and fighting for, and that's what they were talking about. And I want to thank you for suffering through those questions. So at this point, there's peace of mind that's got nothing to do with the outcome of this case. So it
Harden proceeds to talk about justice.
Sure, and it harkens back to the questions themselves. The questions themselves in voir dire talked about whether the jurors had a preconceived notion. Not that the defense was saying that. So it was talking about the jurors having that preconceived notion in whatever way that was based upon race. And he said it was very uncomfortable, and it is. But the jurors, none of them said that. Mr. Riddick even went and said, hey, do any of you fault me for asking you about that? And none of them said anything. And so when you're hearkening back to that, was the wording could have been different? Sure. But there's nothing in that wording that shows that Mr. Mitnick was going to the level of accusing the defense of the only reason they're making that defense is because she's African American. There's nothing in there about that. And the trial.
Again, that's the first part before the sidebar, where it's the two are referenced in the very same sentence. I mean, you can see why the other side is making the argument, right?
I see the argument that they're making, but
I don't really understand why those two were in the same sentence. Can you justify that?
It's part of when you're talking about topics in closing argument and rebuttal argument. And all I can think of is from a trial lawyer's mind. You're trying to do one thing and then you're talking about. But
I mean, can we at least agree on this?
Sure.
This first part here, where they're both packed into one sentence, that's getting at minimum. That's getting pretty close to the edge, right?
I think that
Or do you think that's perfectly fine?
Now, I think that it matters what happens after that. I don't think you can take.
No, I didn't ask you to admit that we went over the edge.
Okay.
I asked you, to be frank with us, is that getting close? At least, getting close?
Is it getting close to
to the edge?
If Mr. Mitnick wanted to say after that I think that that's what they're doing in this case, the defense is.
Okay, so implicitly, and potentially implicitly saying it's not enough, he has to actually expressly say it.
It has to be something that there is a racial, when we're talking about stuff, especially when we're talking about things like Murphy, when you have to, there has to be explicit comments made. You can't be talking about implicit things. Now, obviously, Murphy talks about.
I'm not entirely sure we're in the Murphy world, but.
Okay, sure, but it's mentioned. And so Murphy was the one that talked about, oh, well, these racial comments.
Isn't Murphy when it's not objected to, when it's not preserved?
Correct, it is.
I think probably we're not in Murphy here, that's my opinion, but
Sure.
if we're not in Murphy.
Even if we're not in Murphy, when you're talking about racial comments, the cases that have been cited to the court, they are not cases where it was implied, or even in any way. Short of it, long of it. But we're talking about.
Just to be clear, I didn't ask you to admit that we went over the ledge.
Sure.
I'm just asking if we're kind of getting close here.
I think that what I'm going to say is this, putting the two in the same sentence, probably not what I would have done.
Probably not good.
Probably not, and frankly, I think if Mr. Mitnick was here, who's a very experienced driver, he probably would have said, yeah, I probably should have put them in both in the same sentence. But the jury didn't hear what the appellant says that he said. And afterwards, they heard very clearly Mr. Mitnick say, the reason we did that was for all the parties to know that that wasn't going to be an issue in this case. And we thank you for that not being an issue in this case. And there's zero evidence that affected the jury's verdict in this case. Nothing. It's assumed that it is by the appellant. There's nothing that says that it actually affected him. About a minute left. I don't know if any other court has any other questions, but if not, when you look at this case, the trial court, this court would have to determine that the trial court abuses discretion. That is a high standard. We believe that the trial court was well within discretion on every single thing that has been set forward in here, and we would ask that the court affirm both the jury's verdict as well as the order denying a new trial. That was done by the trial court. Thank you.
So that paragraph that Your Honor read did put us over the edge. But if there was any question, all you have to do is look at the next page. Thank you. You clearly said, quote, you believe the concept of equal justice and justice for all are not just words. They are something worth standing up and worth fighting for.
What would if you had plaintiff respond? If they perceived, for lack of a better term, a racial dog whistle on your part, rather than making what appears to be an attempt at an inoculatory statement on their part, how would you have them respond to what they perceived from you?
If we had made a dog whistle,
They seem to have thought that you were trying to suggest a correlation between the race and the veracity of their client. They were addressing that by saying, hey, juror, you said that you weren't going to buy into that sort of stuff. What would you rather have them do?
well, you cannot bring race into a case, and we did not. And there's nothing in this record whatsoever that suggests that we were challenging her truthfulness because she was black. That's exactly what is not in this record. There's not one iota of that. And, what we
Why not stop that during jury selection? Why not object and stop that during jury selection?
We probably should have. I agree. But what we're dealing with is the rebuttal closing argument that there was an objection. And one thing that this court, that I neglected to mention, was that if this court finds that it was improper, it's not our burden to prove, to show the court that this contributed to the verdict. It's plaintiff's burden if there was an error under Special versus West Boca. The plaintiff has to show no reasonable possibility that this could have contributed to the verdict. And there is no way that they can do that because race is such a sensitive, passionate issue that inflames the passions of the jury, that even though we're not at Murphy says, look, one of the things you can't talk about is race. You just can't do it unless, as the United States Supreme Court says, it's inextricably bound up with what the trial is about. This trial is not about equal justice and standing up something about worth fighting for. This is an auto accident case. It's about money. That's what this is. But it was turned, it's clear that this was a dog whistle, whether intended or not, that this was intended to alert the jury about an issue. It's the same thing if I said to your honors, do not think about a yellow banana. The first thing you're going to think about is a yellow banana. When you say, we want to make sure no one's thinking about race, that's what they're going to think about. And also saying, well, no one said that they raised their hand and said that they had a problem with it. No one's going to raise their hand and say that they're racist. I mean, I find that a silly argument. I want to mention the demonstrative aids. Counsel said, well, we don't really know what the demonstrative aids were regarding the accident, but in fact we do, and they're found in the record at pages 5884 to 5889. Shows exactly what the demonstrative aids were regarding the substantially similar accidents. And again, as Your Honor said, this is all relevant, and under special, they have to prove that this did not possibly lead to the verdict. For that reason, we would ask this court to reverse and remand for the trial.
Thank you.
Thank you.
There's a well-argued case by both sides. Thank you, both of you.